Hello viewers, how are you? Today I am going to discuss with Constitution law. Okay, under the topic right against exploitation, Article 23 and 24 of Indian Constitutions. Here, Article 23 explained about prohibition of traffic in human beings and forced labor. Article 24 explained about prohibition of employment of children in Factories Act. Okay, not Factories Act, factories or child labor under Article 24. First, I'm discuss with Article 23. Article 23 explained about prohibition of traffic in human beings and forced labor. Here, traffic in human beings and beggar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. The point number 2, nothing in this article shall prevent the state from imposing compulsory service for public purpose, and in imposing such service the state shall not make any discrimination on the grounds only of religion, race, caste, or class, or any of them. Here, the protection of Article 23 of the Indian Constitution is available not only against the state but also against the private person. It is a fundamental right of all citizens and non citizens of India that they cannot be compelled to work except by imposing by the state to work compulsory for public purposes. The Article 23 prohibits number 1 is traffic in human beings, number 2 beggar, number 3 other similar forms of forced labor. Here, the expression traffic in human beings means dealing in humans beings like chattels, that is buying men or women like goods, buying men or women like goods, how the goods are selling and buying, right? Similar that. It includes immoral traffic in women or girls, or subjecting children to immoral or such practices like slavery. The word beggar has not been defined in the Constitution of India, but it has been defined by Molesworth as labor or service extracted by a government or a person in power without giving remuneration for it. And also, I want to explain the term of a beggar meaning is involuntary work without payment. It constitutes the two elements. Number one is it is to compel a person to work against his or her will. The point number two, he or she is not paid any remuneration for that work. The expression forced labor in Article 23 of Indian Constitutions giving a meaning widest amplitude, and its interpretations covers every possible form of forced labor, beggar or otherwise, and it make no difference whether the person forced to give his labor or service to another is remunerated or not. In pursuance of Article 23 of Indian Constitutions, suppression of immoral traffic in Women and Girls Act 1956 and Bonded Labor System Abolition Act 1976 were passed, Under the Bonded Labor System Abolition Act, a person guilty of extracting bonded labor is punishable with imprisonment, which may extend it to 3 years and fine of Rs 2000 rupees in a year. Based on this act and article of 23 of the Indian Constitution, one of the leading case was brought before the Supreme Court. The case name is People's Union for Democratic Rights versus Union of India in the year of 1982 All India Report. In this case, the Supreme Court considered the scope and ambit of Article 23 in very detail, and also the Supreme Court held that the scope of Article 23 is wide and unlimited and strikes at traffic in human beings and beggar and other forms of forced labor wherever they are found. The Supreme Court passed the order based on the when mentioned cases and also related cases brought before the court. Basudev, BASUDEV, Basudev versus Mittal in the year of 1962. Based on this case, the court opinion that beggar means labor or service extracted by government or a person in power without giving remuneration for the labor or service. Thus, beggar means involuntary work without payment. It is an indigenous system under which landlords sometimes used to compel their tenants to render free services. What is prohibited by Article 23, subclause 1, is the act of compelling a person to render gracious service where he was lawfully entitled either not to work or to receive remuneration for it. And also, another leading case was discussed and brought before the court, San- Sanjit Roy versus State of Rajasthan, All India Report 1983. Based on this report, based on this case law, it has been held that court gave order the payment of wages lower than the minimum wages to the person employed on famine relief work is violative of Article 23. So, when a convict is sentenced to rigorous imprisonment and forced to work in execution of his sentence in jail, the forced labor extracted from the prisoners should be suitably compensated by amount of reasonable wages for the work taken from them. Was discussed from this Sanjit Roy versus State of Rajasthan case. And another case law also discussed in court, Dina versus Union of India, All India Report 1983. This case was held that labor, labor taken from prisoners without paying proper remuneration was forced labor and also violative of Article 23 of the Constitution. This is also court was ordered through this case and also explained in the year of same All India Report 1983. Prison reform case also brought before the court. The judges discussed and it has been observed that prisoners are entitled to the payment of reasonable wages for the amount of labor extracted from them while serving the sentence in the prison. And also the court directed that the state should pay rupees 8 rupees 8 only 8 rupees per day wages to prisoners for their work instead of prevailing rate rupees 1.60 per day. The court, however, retained from directing the payment of minimum wages to the prisoners by the state as they were not fully skilled in doing such works. Okay, and another case is also discussed, brought before the court, Gurudev Singh versus State of Himachal Pradesh. In this case was All India report in the year of 1992. It also held that prisoners of various categories in all the jails in the state are entitled to be paid reasonable wages for the work they are called upon to do in the jails and outside the jails, and the government must pay minimum wages as notified by the state government from time to time under the Minimum Wages Act 1948 to the prisoners. If the state fails to pay minimum wages, it would be forced labor within the meaning of Article 23. So the court directed through this Gurudev Singh versus State of Himachal Pradesh to the government and other peoples. This is violative of Article 23. And also Bandhu Mukti Morcha versus Union of India All India Report 1984 case also brought before the Supreme Court. This case was discussed and court held that when an action is initiated the court through public interest litigations alleging the existence of bonded labor, the government should welcome it as it may give the government an opportunity to examine whether bonded labor system exists and as well as to take appropriate steps to eradicate that system. So this is the constitutional obligation of the government under Article 23, which prohibits forced labor in any form. So Article 23 has abolished the system of bonded labor, but unfortunately no serious effort was made to give effect to this article. It was only in the year of 1976 that Parliament enacted the Bonded Labor System Abolition Act 1976, providing for the abolition of bonded labor system with a view to preventing the economic and the physical exploitation of the weaker sections of the people. And I'm going to discuss the same article 20 subclause 2 of the 23 subclause 2 of the Indian constitutions explained about compulsory service for public services. Here it contains an execution to the general rule. Under this clause, the state is empowered to impose compulsory service for public purposes, but in imposing such compulsory service, the state cannot make any discrimination on ground only of religion, race, caste, or class, or any of them. For example, compulsory military service or social service can be imposed because they are neither beggar nor traffic in human beings. Another case law, Chandra versus State of Rajasthan, also brought before the court. Here, the Sarpanch of a village ordered every household to send one man along with a spade and an iron pan to render free service for the embankment of the village tank. So the Rajasthan High Court order of Sarpanch was clearly against Article 23 subclause 1, which forbade beggar. And also the court observed that Panchayat could not force any person to perform labor. Okay, you know very well Panchayat Act, many other things is going on in our modern trend, in olden period in village area also. This is what explained about Article 23 of Indian Constitution clearly. And also based on this article, we discussed earlier Sanjit Roy versus State of Rajasthan, Dina versus Union of India. Okay, and another leading cases, Bandhu Mukti Mocha versus Union of India. The Bandhu Mukti Mocha versus Union of India, the Supreme Court held that when an action is initiated in the court through public interest litigation alleging the existence of bonded labor, the government should welcome it, as it may give the government an opportunity to examine whether the bonded labor system exists, and as well as to take appropriate steps to eradicate the system. Okay, we discussed earlier, this is the constitutional obligation of the government under Article 23, which prohibits forced labor based on this case law. And many cases also discussed prohibition of employment of children in Factories Act is available under Article 24 of Indian Constitution. Here, now I'm going to another article, this going to discuss another article, Article 24, the related topic, right against exploitation topic. Article 24 explain about prohibition of employment of children in Factories Act. What is that prohibition of employment? The Constitution prohibit employment of children below 14 years of age in factories and hazardous employment. This provision is certainly in the interest of public health and safety of children. Children children are assets of nation. So that is why Article 39 of the Indian Constitution impose upon state an obligation to ensure that the health and strength of workers, men and women, and the tender age of the children are not abused, and that citizens are not forced by economic necessity to enter a vocation unsuited to their age or strength. Based on this, we discussed the People Union for Democratic Rights of Union of India case brought before the Supreme Court, and also discussed in this Prohibition of Employment of Children Act, and also another case law, MC Mehta versus State of Tamil Nadu. MC Mehta was a advocate. He filed a case against the person with the help of Article 32 of Indian Constitution. This is a fundamental rights, and he filed in based on this Article 32 to file the case before the Supreme Court. The Supreme Court was discussed and explained and directed that children below the age of 14 years cannot be employed in any hazardous industry, mines, or other work, and has laid down exhaustive guidelines how the state authorities should protect economic, social, and humanitarian rights of millions of children working illegally in public and private sections. So that the matter was brought before the court by a public spirited lawyer, MC Mehta, by way of public interest litigation under Article 32 of the Indian Constitutions. He explained to the court about the plight of the children engaged in Sivagasi cracker factories, Sivagasi factory. Though the Constitution provides in Article 24 that the children should not be subjected to exploitation, and the law prohibits employment of child labor, and it casts a duty on the state to endeavor to provide free and compulsory education to the under the age of 14 years. And Article 41 also, there are 17 million children working in the organized sector as estimated by the planning commissions. Okay, so despite the constitutional provisions and various legislative enactments passed by many states which prohibit employment of child labor, the child labor is a big problem and is remained unsolved in modern days also. So what happened now? The Article 45 of Indian Constitution explain in this age, duty of the inspector to see, that is the inspect to the factory, okay, under the factory act also, and everything is explained, many cases. And now the separate law also enacted through labor law, okay, through the labor law the factory act also inserted based on this article 23 and 24 to prohibit the child labor. And Salal Hydro project with versus state of Jammu and Kashmir, one case also brought before the court under article 24 of Indian constitutions. In this case, the court has directed the construction work being hazardous employment. The children below the age of 14 years cannot be employed in the construction work because of the constitutional prohibition contained in article 24. So, considering the socio-economic problem and the interest of health and the strength of young persons, the Constitution under Article 24 has put partial restriction on child labor. Under Article 24 of the Constitution does not prohibit their employment in any innocent or harmless job or work as economic conditions led children to work in order to supplement the family income, because this is the main reason. However, the prohibition contained in Article 24 against the employment of child labor was restricted only to factories, mines, and other hazardous employment only. The rest of the things, the child also working minimum 2 years or minimum 2 hours or 3 hours, getting money for the protecting their family. So, what is my suggestion through this article? We have a lot of government also already started labor department. The labor department to create a legal awareness program conducting all the taluka, district, and the state level. The government should appoint any one of the officers to monitor the children below the 14 years of the men and women. So, if the inspectors or any officer of child officer or child welfare officer to verify the each individual houses and to check the through the census or enumeration method, they know how many children are residing that particular locality. That meaning is locality, meaning is location, that meaning is taluka or village or town area or particular ward, okay, particular street. So the government should allocate the particular area and monitor to enumeration. Monitor means the personal liberty will not violating the children's also should get enumeration how many children below the 14 years. So based on this, how many children are going to school to study their education, and how many students not study, and how many students are working in outside area below 14 years, and also how many students are staying inside of the house, not going out, not going school, and not going any work, simply staying in their parental business, okay. So these should be monitor and give awareness program to the people, and should also census the needy peoples, those who are poor people, economically low. The government should give basic needs to the family and adopt the family with the help of NGO. Many NGO is available. So this kind of eradications, this kind of prohibition of children staying in the home, children going to the work for the purpose of protecting their basic things life every day. They have Article 21 also protection, personal liberty and protection of life, their family. But we are not violating the privacy and all. We should enumerate the students' name below the age. That's all. We do not want to take and photograph and all. How many of you students are staying inside of the home? That particular students will get it and give the legal awareness and health awareness along with the medical doctors and health visitors and enumerator from the labor officers or labor services or any other appropriate officer appointed by the government protocol. I don't want to interfere in any other government sites. Okay, I'm giving guidance only because government having powerful department, government know all the protocol and all. Okay, I'm giving suggestion for the society. So should reach to the all childrens below the 14 years should study. Okay, not working. This is the situation. Okay, viewers, I'm going to conclude